So first of all, I want to say Chrissie Doubae, and I'm a bit of a binary person, so I have my one side which is all this, which is all the logical, technological innovation space, which is where I generally work on commercialisation of new technologies, which is endlessly interesting and challenging. And then I have my other side, which is much more fun, and that's all my cabaret work, and we're looking forward to Mardi Gras having a very big presence with the tropical fruits from up north. So at the moment, I'm trying to balance the two sides of my personality, which is quite a struggle, but still great fun. Somewhat interested in new clients in the technology sector, and to compete with your sunset cruise on the 1st of March, we have yet another Transglomerate Cabaret night.
But that'll be after the Sunset Cruise Fest.
Oh, that's right.
Everyone can come from that up to
Okay,
Yeah.
good point.
And you'll be dragging a lot of people.
It starts at 9 and the party's on, so it'll be a really good kick-off for Mardi Gras, both will, I'd say. With business cards, I find these smaller pieces of paper easier to keep track of than the classic business card, which I'm finding really hard to deal with. Usually end up looking on the email or the website or something like that. It's an interesting subject. So, should I speak now?
Yes, the floor is all yours, Dr. Doubae.
It's mine, okay. So,
That's something like Dr. Doubae.
I was going to say it rolls nicely.
Resuming my... So I spent many years in laboratories working on this next issue of commercialisation of technology, working on experiments associated with theories, also called hypotheses. And the federal government, in no less a person than the Prime Minister and previous governments, have all said they want innovation. There's quite a large program. I think nationally we spend about 10 billion a year, of which about a third goes to the private sector. And they struggle with it. They've just had a review which they published saying they want more collaboration, they want more incentives, and at the end of all this comes the even more vexed subject of, or challenging subject of intellectual property. So I thought I'd put my credentials up just to show you I know a bit about it. So our little team, we've got lots of experience. We're actually licensed tax advisors in the R&D tax incentive programs, and we work from the bench to the balance sheet, which is quite a long distance. With intellectual property, as we were discussing earlier on, that the intangibles currently account for some 2/3 of the market capitalisation of a lot of companies. And I think we just had a really spectacular example with SpaceX and Elon Musk, who's just beyond belief fantastic in my opinion. The way he's got 3 businesses that I'm aware of, being the batteries, the cars and the space program.
And body disposal now.
Sorry?
Body disposal.
Into space.
Really?
Of Mars,
Yeah.
Okay, well...
The murder case, there's no evidence now.
Yeah, exactly. Yes.
Well,
I think of that.
Leave that one. So just as a segue to your point about your friend's comment, that the whole point about intellectual property is that these words and terms and colours and styles that are used are the way we communicate and differentiate ourselves, and it's our own names, our own style, and it's the know-how, it's really our life's work is distilled into this area, in my opinion. So when we were talking earlier as well, one of the key points is to navigate the space, and every time a project starts, there's issues about, well, what is the business name that's going to be used? You know, what is the potential brand name? Is there a code name? And all this needs to be checked. You know, the question of registration of business names, checked on the ASIC website to see what's out there already and to see to what extent you might be differentiating. The same with brand names and designs, because if you have a great brand name and it turns out that some corporation's already got it, you're just heading for disaster. Plus, there are other issues around what the words mean in foreign languages, which can really be quite tricky. The technical prior art. So I'm basically skimming over each of these topics.
Can I ask what technical prior art means?
So that's, we'll get to that, but
Alright.
it means patent literature. So it's a jargon term that gets used. But I think it might extend beyond that to you know, trademarks. You know, always who's out there, what have they got, what else has been done, what's available, and I guess intrinsically there's risk about infringement, which is challenging territory. But you know, in the whole question of where does this intellectual property manifest itself, and the answer, it should be in the balance sheet. But we collide with the requirements of the accounting standards, which have quite definitive statements about what is allowed on a balance sheet of a company. And it's something I find problematic, because if directors of a company can't value what their the cost of their registrations or their brand names, at least to a minimal extent, $1 for example, then they tend to be forgotten. With listed corporates, there's usually something in the notes about to what extent any of this has been capitalised, and the issues around acquisition of other companies and their intellectual property and writing and treatment of goodwill, as it's called. But that last line there about planning to deliver the value of your assets, it's absolutely profound. I must admit, I struggle with it, because it's like, well, are you developing something that has intrinsic value apart from your own involvement in processing work? And that is the great challenge of businesses, because sure, we all want to earn enough revenues to pay the outgoings, but also we should be planning for ultimate sale on to another corporate. So just, you know, of some of the issues that are, I guess, covered by the general term intellectual property is, yep, copyright, secret know-how, which is one of my favourites, trademarks, patents, designs and registrations. So the point I was making was that each of these is a profound subject in its own right. But just briefly, so copyright, also really interesting. So it's created, anything that's created by an author is subject to copyright. And what's brilliant about it is it's conferred on the author the moment it's created. So it applies to any created work, like this presentation, for example, and music and art and movies, all the way through to computer programs. I'm sure everyone is aware that the end user license agreement in a lot of software programs is all about agreeing not to copy the computer program, the intrinsic code behind the programs.
I've never read one.
Oh, but they're really interesting read.
Is copyright going to continue into the future, do you think?
And
Do you think copyright will continue into the future? I just see the music everyone's going copyright for copyright, but there's so much music out there, sooner or later you have to say there's no longer...
That's right, the risk of overlap
Yeah.
is, I agree with you, but there's been a couple of spectacular cases about it.
Yeah,
Was it the
Bee Gees, well,
Men
not
at
Bee
Work
Gees,
track?
no. Beach Boys
Men at
went
Work
for
was-
something, Men at
Yeah,
Work.
yeah.
recently.
And so again, one of the other points in the technology space in particular is secret know-how. So the trick with secret know-how is to make certain it stays secret, so that it's not published or released or divulged anywhere. And of course, as we know, there's a lot of skullduggery around that zone.
Is that why the font's so small?
Yeah.
Sorry?
You can't see it.
It's why the font's so small because it's secret.
It's
Secret. The fine print.
But there's a nice example of secret know-how, like how to synchronize, as you can gather, I'm a big fan, how the 27 rocket engines. I think the Russians tried it and it failed. But there's a heap of distilled technologies up on that one image. And then you do also see on these images now, you know, no image may be subject to copyright, and there's all these rules, the legal rules about to what extent you can use this. So for example, if some corporation decided to use it to promote, you know, space ice cream or some such product, then they run into the risk of they infringing the copyright, and action may follow. So I think it's just magnificent, real 21st century stuff. So then there's trademarks, and they're subject of registrations with Intellectual Property Australia, and classics like Coca-Cola and IBM, which happily has now been changed to a rainbow IBM, which is a huge change. And sometimes there are colours, sounds that are really meant to represent the identity of the corporation and its products. It really defines territory whereby the owner of the trademark has a monopoly right, and I think there's been a long case where Cadbury's were trying to trademark the colour purple in the food sector, field as it's called, and it's a struggle because I think we all think purple should be available for general use.
Yeah, that's like ANZ, their blue is that they trademark their colour blue and things like that. I don't know how you can trademark a colour. I've always thought that was a bit bizarre.
It's to do with the Pantone colours.
Yeah,
so
that's right.
You can, they're so specific within the 3 digits that identify a particular shade. And you can have 3 sets of those colours or 5 sets of those colours, and the combination is what you trademark. It's not the actual colour blue. It's the makeup of it.
And
Colour tones.
Yes.
at some point, I think all of these aspects of intellectual property should be on the action list for any project and any set of financials, and that's another great challenge. And then we get to patents, which is a fascinating subject. Letters patent in a lovely small font there for you all, cramming it all in. But one of the points about patents that people don't quite appreciate is the term itself. Patent actually is from an old English expression called letters patent, which meant open letters as opposed to letters sealed under seal, you know, the wax seal. And it was originally a grant of a monopoly right for anything, and some of the early land grants in Massachusetts were under letters patent. But then it was limited after review in British Parliament to inventions, and the whole aim of this was to confer a monopoly right on the inventor with a view to encouraging them to teach their secret know-how to others in return for royalties. And I think this gets obscured in the processes at times. But one particularly interesting one was that the CSIRO invented the 802.11 wireless protocol and took out a patent on it. And it was actually for transferring radio physics data from Parkes to Marsfield. And then it was picked up and used by all the majors in the wireless protocol, Wi-Fi as we now know it. And CSIRO took them to court in Texas and won $500 million after a major battle, so enforcing their monopoly right on the sector. But it's, you know, the requirement is it's got to be absolutely novel, meaning there's no prior art published, meaning that no one's ever divulged any work in this particular topic. Involve in inventive steps, so you've got to actually done something particular, and be capable of industrial application, be useful. And equally, you've got to teach the method of the invention, and there's all kinds of tricks in how to do that. I hasten to add that there are intellectual property lawyers. They're all now in Australia, nearly all of them listed on the ASX. They're all public companies, and they like patents, and patents are great, but it's just one element of this intellectual property strategy, and that's where I feel there's a great opportunity still, which is what I was looking at, designs of...
So, Chrissie, with patents, does that kind of work at opposite? Is that with your secret know-how and your patent, they seem to be conflicting?
Well, they are, because, and that's the point, is if an inventor, you know, says, well, I've got to get a patent on this, and so, as the language goes, and applies to one, then they've got to actually teach the method of their invention. So they've got to put it out to the world. This is not well understood. Yeah. It really isn't. And so, like, first of all, it should be, well, I'll try and contain it as secret know-how, and then I might try and teach some particular part of it. But if you want to, you know, follow the technology, you'll need the whole package.
So is it enough to apply for the patent? Because you often see patent applied for. So once you've done that, is that enough to cover you then if you do go out and teach it?
Well, theoretically gives you a monopoly protection. However, again, the reality there is you have to be in a position to enforce it. So the CSIRO, you know, were able to go and haul the other, you know, infringers into court in Texas, which would have cost quite a lot. And if you're a struggling startup, then maybe you don't want to think about doing that.
What's the difference, copyright, I call it patent. What's the difference with copyright and patent? Because they're very similar.
Well, quite right. They're all part of intellectual property.
Exactly.
Copyright is, I guess, the reality is you're putting the creative piece of work out in the public domain, and you're doing it with protection of copyright. With a patent, you're actually teaching a piece of technology.
Is it because it's innovative? Patent is an innovative
product? Yeah, okay. Very good. And just by the way, like corporations, in particular Apple and Samsung, like they have thousands of patents, like tens of thousands of patents, and they regularly slug it out in court as to who's got monopoly right on which particular field of application. But yeah,
some of them seem really nitpicky. It's really like with Apple and Samsung. And there's a patent for who has a rectangle with rounded corners.
Yeah.
But they're worth billions to them. So.
Yeah, I know, but why? How does that get?
Well, I think the aim is the aim is to lock out the competitor.
Yeah, I understand why, but the question is how? Can you get a patent for a rectangle with rounded corners?
Design shape.
Sounds like a
Part of, all
corruption.
part of the strategy.
And also because you're going to apply it in certain ways, which was one of your criteria,
Yeah,
is that if there's no application, then people wouldn't be bothered with it.
exactly.
But because there's significant application, and it's
Exactly.
worth a lot of money.
That's right, and so then you get with design. So, for example, Apple were famous for their designs and ergonomic aspects of design. Design's a whole subject in its own right. Still, again, not particularly well understood, but part of the package. And you can register designs, and again, it's if you have a particular style in your product, then you can have that registered, and then if someone tries to copy it, then you can take action against them.
It's like when you go on Google and you look for some designs. There's some designs in Google you can use, but you have to double check if it's got a copyright.
Exactly.
If it has a copyright, you stay away from them.
Well, that's the copyright, but there can also be registered designs.
Yeah.
You know how you've got a patent and you actually have to take an action to release it, to publish, to show people?
Yeah.
Is it the same with copyright? So if you've done some work and have never actually released it, is copyright still applicable on unreleased work?
Yes, I mean you hold it. It's you conferred, a right conferred on you the moment you create it.
Yeah, but you don't actually have to then
No, you don't
release or
publish it.
share or publish or...
That's right.
Yeah.
It's all part of the process of managing intellectual property. So yeah, I think design is again such a substantial subject, not particularly well understood. And then we get to this point about registrations, and I again struggle with this because if you're a company, and I'm guessing you'd be licensed, wouldn't you? Financial services license. If you don't have the license, you can't operate. So, in your own balance sheet, how do you value that? It's like, it certainly costs something. There's a cost of the registration at least. And it has value because, and it represents part of your, well, intangibles certainly, but intellectual property behind it there as well, all the training you've had to get it. I find it just extraordinary how that again often doesn't even feature on statements of financial position as they're currently called. Another piece of joy. Domain registrations, again, like they're getting harder to find. The ASIC registrations, all those points about brand names and company names, like if you don't have them, then you can't operate. So these, but where's the value in them, and how do you add value to them? Can be unsold. I personally aware of lots of folks who just start off with some generic name or their own name, for example, like Henry Ford, so it's called a Ford. It's like, is that a good brand? I don't know.
I'd like to own it.
It's not doing too bad.
Well, and then calling the car company Elon Musk created, Tesla, after Nikola Tesla. I think that's good, but the really good brand names, from my point of view, was like Microsoft, because it was micro computer software. Nice constructed word, conveyed the meaning of what it was all about, and really has stood the test of time. Apple is a brand I'm not so sure about. Sorry?
Google?
Google's good, yeah.
Where did that come from? Is that just made up word?
Yeah, exactly.
No. Google is a terribly large number.
Is it?
Yeah. I figured it's one followed by X number of zeros after it.
Is it?
It's an actual thing.
Is it
Google.
really? See, that's a good, well carried.
I'll Google that while we talk. And give you the actual.
Yeah, okay. As I said, it's a big subject, and I'm skimming everything. So the points to be aware of. There's awareness, like what is in the prior art. And I again, and you know, I struggle with this myself, but I feel that more people need to have some time spent on what is being published in their sector. You know, what is being, for example, so someone taking out a patent in an area that where you're working and it cuts across what you're doing, well, chances are you either should stop or you've got to change strategy. And I've certainly been involved with that, and it was unpleasant.
How do you find out if somebody's cutting across your territory?
Well, it's published in the go to Google and see. There are registers in Intellectual Property Australia and the US Patents and Trademarks Office and European Union Office of the Intellectual Property, so it needs to be searched out.
Sometimes you have to run into them though.
Yeah.
Yeah.
So
It's not exact.
if, for example, somebody was going to patent a product that I had in first trade, would IP Australia be proactive in contacting me and say, you've got this product, somebody's trying to patent this, can you prove when you started this product? Would they do that, or
No,
you have to be proactive?
They're just a registration office.
You just got to move quick and put a patent.
Good.
Yeah, but you have to be looking.
So exactly. So,
Yes.
so that's the last one of those four. So the second point was, start to look at how you're going to account for what you're doing. The third point is to get on the receiving end of alerts for what's going on in your sector to the extent you can. And the fourth one is, you know, if you have intellectual property and someone else is infringing your intellectual property, then you need to take action. So write to them and say, please cease and desist, or we'll, you know, see you in court or worse. And equally, if they have to take action as well. So if it's a large corporation, then you basically go, right, I surrender.
Or you annoy a little bit, just to get something out of it.
That's right, or you can manoeuvre. I was actually asked once to act as an expert witness on a case where a large corporate was infringing some software that was developed by a small corporate, and it was all about the damages being claimed. And the large corporate said, well, the small, you know, contractor company had zero value for its IP on its balance sheet, so therefore it was worth nothing, which is actually a compelling argument in my opinion. Interesting. So, well worth looking. IP strategy, asset register, valuations, you know, where are you going with it? Now, this was interesting. I really wanted to finish on this particular point. So, being creative people and my own love for innovation, I was amazed by the story of Gilbert Baker and the rainbow flag and how he invented it. But he did have an inventive step, that it actually has a pink element up here. So it's and I wasn't aware of all this. And meaningful, you know, in a hierarchical sense, which I relate to very well, especially the
Is that
pink
what the
one.
colours mean?
Sorry?
Is that what the colours mean?
We have 6
I
now.
believe so. Yeah.
But there's a few
Oh,
different ones if you
there we
search
were, you know, showing the flag up in the Pride Parade. So, but I think we've got to get the right flag, and it's wonderful. The
Was
comments.
that at Lismore this year? Or one before?
It was one before.
Oh, before, right.
But yeah, the Acon have used it. It's quite a compelling image. But I think, and he said, you know, when he spent a lot of time on this flag, and he said what amazed him was when that was flown as it is in Taylor Square, like everybody got it immediately. It's like, wow, that's fabulous. So that's the point on which I wanted to conclude. Oh, I went the wrong way.
Can you just take me through the colour?
Sorry?
To the colours again?
Oh,
You know,
They dished it in quite a bit.
yeah, I didn't want to.
Yeah, but there's another. I think
That
it's
one?
light
Yeah.
blue that they don't have as well.
Yeah.
But the spectrum is actually 7 colours.
Remember, there are
If you do the history of it,
restrictions around
there's
your
different reasons for
distribution of
different
that
ones.